And
people filtering in. Hey everyone, we're gonna give it a few minutes before we get started just to let some people filter in. Probably about 2 minutes. I'm going to give it 1 more minute and then we will get started. All right, well, it looks like most people have signed on, so I guess we will go on and get started. Hi, everyone. My name is Mallory Gibson, and I am the new Private Attorney Involvement Director at Legal Aid Society of Northeastern New York. Thank you, everyone, for being here today. Before we actually get started with the presentation and the event, I just wanted to say that LASNNY is so excited to be hosting today's event in collaboration with In Our Own Voices. And I'm even more excited to announce that LASNNY and In Our Own Voices have partnered together to jointly host several legal education events like today's, and to also provide legal assistance to BIPOC, LGBTQ, and gender nonconforming survivors of domestic violence and sexual assault, which I'm sure a lot of you saw on our promotional flyers for today's event. Dates for our future events are undetermined, but they are coming soon, so be on the lookout. We don't always think about it, but the law impacts nearly every aspect of our lives, right? Health, employment, education, housing, family matters, just to name a few. And unequal access to and discrimination within these areas can and do create real barriers, especially for the traditionally marginalized populations, such as low-income persons, people of color, women, persons who are LGBTQ or gender nonconforming. Unequal access to our court system shows up when people, especially marginalized groups, fear the system. They see it as financially inaccessible, they don't have a lawyer, or they don't have information or knowledge of their rights. When we provide traditionally marginalized persons with access to justice, it better enables them to tackle these inequalities and to participate in legal processes that promote inclusive growth in all other areas of life. So breaking down these barriers that exist in our justice system is vital, and that is the focus and the intent, or what we're hoping to assist with by hosting these events. And as an aside, we at LASNNY and in partnership with In Our Own Voices, we've been brainstorming legal issues to provide for our future educational events. But if anyone here has any specific suggestions or ideas, feel free to let me know directly or drop a comment in chat. Panelists are the only ones who can see the chat, so you don't have to worry about anyone, you know, judging the ideas that you put forward or anything. So yeah, if you have any ideas, let us know. And with that, I'm going to go on and introduce our amazing panelists today. We've got three: Nick Randall, David Crossman, and Shruti Joshi. Nick Randall is an Assistant Deputy Counsel to the New York State Senate Majority Democratic Conference in Counsel's Office, and she literally helped draft much of the language in some of the laws that we will be discussing today. She further contributes to the legal profession through her pro bono services with LASNNY's Closing the Gap program, which we are thankful for at LASNNY. And she also provides career and educational advice and guidance through University of Albany Career Advisory Network and the Albany Law School Alumni Initiative in mentoring. And she is a mentor with the Capital Region sponsor of Scholar College Success Program. David Crossman is a staff attorney at Legal Aid Society of Northeastern New York, who has handled housing matters and eviction defense, primarily in Schenectady County since 2017. He is a graduate of Albany Law School, and prior to becoming an attorney, he specialized in redistricting, staffing the Vermont Legislative Reapportionment Board in 2011 before becoming a redistricting clerk in Region 1 of the state of Alaska. David is looking forward to transitioning to in the near future into a position as a staff attorney for LASNNY's Medical Legal Partnership in conjunction with St. Peter's Health Partners. He lives in Rensselaer County with his wife Jane and their rescue dog Bam Bam. Last but not least, Shruti Joshi. Shruti is a senior attorney at the Legal Aid Society of Northeastern New York and works with Foreclosure Prevention Project, where she represents low to moderate income homeowners facing foreclosure in the Capital Region. Shruti started her career as an in-house counsel specializing in intellectual property law, but was quickly enthused into public service after relocating to the Albany area and volunteering at Legal Aid. She has been at LASNNY since January 2016. And with those introductions, I'm going to now turn off my camera, monitor the chat for questions, and let our panelists take over.
Great. So my name is Nick Randall, as mentioned. I work for the Senate Majority. I supervise about 10 committees. One of them is Housing Committee, and the other relevant here is Judiciary. So a lot of these things that we're talking about kind of fall into those committees, which is how I've been involved. Here is just a roadmap of what we'll be going over today, and we wanted to get started with the recently passed emergency rental assistance program. It's part of the state budget this year, with much of the funds coming from the federal relief, CARES Act and CARES Act 2 programs that were passed last year in December. OTDA will be administering this program. It will provide 12 months of rent assistance and utility arrears assistance, plus an additional 3 months of prospective rent assistance. The portal is not yet functioning, but it will be up in the next couple of weeks, we hope. And it will be a statewide portal where applicants can do a pre-screening kind of questionnaire. And then after the pre-screening, they'll be able to submit all of their application materials online through that screening tool. There will also be on the ground offices with where community support organizations will be able to assist in the technical aspect of applying for the ERAP program. You would have to show that you experienced a financial hardship during COVID, or that you're at risk of homelessness or housing instability, which can just mean that you have received a notice from your landlord that you are behind in rent and that they intend to pursue an eviction. For the federal funds, a household can be eligible if they earn up to 80% of the AMI in their area, which in Albany County for one person is $54,000 and $320. There is priority for the most vulnerable residents. Those are people who've been unemployed for at least 90 days and earn up to 50% AMI, which is for one person about $33,000 annually. There's also a priority for veterans, people who are domestic violence victims, people who are human trafficking victims, small landlords, and also households with actually pending eviction cases, and also mobile home park tenants. Undocumented immigrants are eligible. They do not have to disclose an immigration status. The program will allow self-attestation. So if you can't show that you experienced a hardship, a financial hardship, for example, you work under the table or you work on tips and you haven't been able to demonstrate that you lost income because of or during the pandemic, a self-attestation would be permissible in reviewing that application. And also other people with knowledge of your circumstances could also provide supporting documentation in the form of a self-attestation to support your claim. So if your financial hardship is that your parent had to move in because they became very ill, and therefore you had an increase in out-of-pocket costs that made it difficult for you to keep up with your rent, that is a financial hardship that would qualify for assistance under this program. Tenants can apply for the program individually, and the agency will try to get in touch with the landlord for them. Tenants can apply with their landlords so that they have a joint application, and those applications are likely to be processed faster. Or landlords can apply on their own, and if the tenant does not cooperate, the landlord may have access to these other funds, this hardship fund, which is the $100 million here that you see as state funds. And those will be for landlords whose tenants don't want to participate, or who maybe their tenant moved out before the program was up and running, but left with a substantial amount of arrears, for example. There are a number of tenant protections for people who are approved or people pending applications. So a tenant cannot be evicted while their application is pending. So you can do the kind of pre-screening component of the website. And if you get through the pre-screening component and you're in an active application period, you cannot be evicted while your application is being reviewed. Your rent arrears will be paid directly to landlords, but if you have a landlord who is just not cooperating, the agency will hold those payments for 180 days. And that reserve payment establishes a rebuttable presumption against the landlord in court if the landlord still tries to evict that person. There is eviction protection for a year from the payment of arrears, except for people who are causing an issue in the building or for future non-payment. So if the program pays off your arrears, say in August, you would be protected from eviction for a full year unless you fell behind, in July or September, something like that. The late fees would have to be waived in order for the landlord to get this payment, and there would be no rent increases during the year of protection. There are a number of other emergency rent programs out there that you can apply for now. They are much more limited in their scope and in what is permissible. So if you do need to apply for other kinds of rent arrears, I do encourage you to go to the OTDA website or your local DSS office in order to apply for other types of rent arrears. And here are just a quick summary of what some of those programs are. There is emergency assistance for adults, there's emergency assistance for needy families, there's safety net assistance, and in New York City, there's also FEPS or one-shot deals. The state budget this year did establish a new transitional rental assistance program. It would provide some supplements to households that are homeless or are facing imminent loss of housing, but that funding goes through local agencies. So you would still have to go to your local DSS office to apply for that. And so as we move forward, I'm going to pass this off to David to do an overview of what eviction looks like in, I guess, the normal times. And then we will start to talk about what kind of tenant protections we have across the state due to the pandemic.
Thanks, Nick. Yeah, so we wanted to go through a little bit of like we said, the pre-COVID process of an eviction. just to kind of outline what normally happens and what will happen now during COVID. So basically, there are two main types of evictions. There's a non-payment eviction that's pretty self-explanatory. The tenant doesn't pay the rent that is owed. Generally, the landlord has to send a 14-day notice demanding that the tenant pay rent or leave. You'll hear people call this a rent demand or a pay or quit notice. And not to get, I don't want to get too far into the weeds, but there are some other notices that are required. There is a 5-day late notice that's required as well, thanks to the Housing Stability and Tenant Protection Act of 2019. And there are some other things that might apply, but the main thing to keep in mind is that there has to be a rent demand before a non-payment eviction can be filed. After the 14 days. Now, if the tenant doesn't pay or quit, the landlord can start the eviction after the 14 days expire. And sometimes you'll see landlords start on the 14th day. That's not allowed. You have to wait until all 14 days expire. So the other type of eviction is a holdover, and that's kind of everything else. You'll hear a lot of people refer to holdovers. There are a lot of different types of them. Generally, just talking here about month-to-month tenants, like when there's no written lease. And in those instances, the landlord doesn't really need a reason, only the proper notice. When you do have a lease and you have a written lease, for lease violations, the landlord has to tell you why and prove why they're evicting the tenant. And if you have a lease that's expired, generally a non-renewal is, again, you don't need a reason unless there's something differently in the lease, only proper notice. So one note I will say here is if you do have a written lease, that's generally where you want to start looking at where your rights are. There are sections there are parts of the statute that make certain things illegal in a lease, but always look to the lease first. And then keep in mind when we're moving forward, the landlord or the person doing the evicting is called the petitioner, and the tenant or the person being evicted is the respondent. And I say that so, because I might lapse into that language because that's how I'm used to talking. So just in case I do lapse into that, I wanted to make sure that people knew what I was talking about. So moving on to the next slide. The one thing there are two things in common with all these proceedings, right? So whether it's a non-payment or a holdover eviction, the petitioner, there it is, the landlord, has to serve what's called a predicate notice. Now, this is just something that they serve before they can start anything. Like we mentioned the rent demand earlier, that has to be served prior to beginning the eviction process. In a holdover, it's a notice to vacate or notice of termination, notice to quit. And I mentioned that where there is no reason, when there's no cause eviction, like a month-to-month tenant, they have to give proper notice. I did just see an email this morning on a listserv that was kind of questioning some of this, but not very well, I thought. If you've occupied the apartment for 1 year or less, you have a 30-day notice. If you have 1 to 2 years in the apartment, it's a 60-day notice, and over 2 years is a 90-day notice. There's case law, and when I say case law, that means what the courts have actually looked at these statutes and kind of interpreted how these things work or how they should be applied. I did also want to flag that what service is first, though. So you know what service is. Service is the formal delivery of court papers. Generally has to be done by someone who's over 18, and it can't be the landlord. Now, the landlord could potentially give you that predicate notice that I talked about, the rent demand or the termination notice, but they cannot serve this notice of petition and petition. And that is what starts the official process, is the notice of petition and petition that need to be served 10 to 17 days before you go to court, basically. So in court, the tenant and the landlord are normally asked to pursue some kind of settlement. Beginning in 2020, there's been a real push in the courts for mediation, and sometimes the courts will have a mediator there. And I should mention that these are proceedings that are in city court or town court or village court. That's what we're talking about here. So there might be a mediator there. There are two things basically that are at issue here. The main thing is possession, right? The landlord wants possession of the apartment. Tenant wants to stay in possession of the apartment, potentially. if it is a non-payment, or sometimes in a holdover, they call it use and occupancy, there is the potential for getting a money judgment for rent or use and occupancy that you might owe. So basically, when you go to court and you're talking about settlement, basically the things that you're negotiating are going to be time left in the apartment or money. So there's a lot of times there's like a give and take. If you can leave quicker, the landlord might waive the money, those kind of things. But that's not required, but it's definitely the courts prefer the parties to talk over their dispute before getting into a trial. And if there is what's called an issue of fact, either side can ask for a trial. Basically, like an issue of fact would be maybe, for example, I don't owe that much rent. The rent that they said that I owe is not the amount that I owe. Or there could be conditions in the apartments. There could be a number of things that could be an issue of fact. It's basically when one side says this happened and the other side says, no, it didn't. That's where you have an issue of fact. And now the trial cannot be scheduled sooner than 14 days after that first court date. A few years ago, it was within 10 days. So this has been a huge help for people like us who are dealing with a lot of clients. It's definitely a lot easier to go to a trial with more than 14 days than less than 10. So moving on to the next slide. If the judge gives possession to the landlord, it's going to issue what's called a warrant of eviction. What happens then is that the warrant of eviction has to be served on the tenant, and that's formal delivery. It's either the sheriff or a city marshal. Generally, it's sheriffs in upstate New York. There are a few cities that do have marshals. And so they serve that 14 days prior to coming to change the locks, basically. So you should get 2 weeks notice of when the sheriff's office is coming back. There are sometimes they might not come back exactly 14 days. And sometimes you could ask the sheriff or the marshal exactly when they're coming back, just so you can have an idea. So if the tenant hasn't left when the sheriff returns to execute, they may change the locks. Tenant will be forced to leave. Now, this cannot happen on a weekend, a holiday, and it must be between the hours of sunrise and sunset. I did have a conversation with a marshal once that I don't know why I think it was hypothetical that he could go at 12:01, and I said, I don't think so. I don't know why you would want to get up at 12:01 to serve a warrant of eviction anyways. But also there are some various local laws as far as what you leave behind and how the landlord must take care of that. State law generally says that the landlord has to keep it for a reasonable period of time. If there's no written lease, again, this is one of those situations where if you do have a written lease, your lease is likely to say something about that. When you do leave, I always urge people, take pictures of any belongings that you have to leave behind. Take pictures of the condition of the apartment, because later on you might have a dispute with the security deposit. So it's always good to document everything that you can. And I think that nowadays a cell phone with a camera can be your best friend. So the next slide. So I did want to give you kind of the time frame. Worst case scenario, and basically when you go to court, you would be looking worst case scenario after your first date, you'd be looking at those 14 days. And then you'd be looking at another 14 days. So you're looking at the very minimum of 28 days from your court date. It's likely to be longer than that, but I always go with the worst case scenario, which has earned me the nickname of the fun police from my wife. So if things do go sideways, you can file what's called an order to show cause. That might be contesting the warrant of eviction. A lot of times that will be when you weren't there at court the first time and you have some kind of defense. There are some other situations where we've done orders to show cause. But basically what this means is that the tenant's asking the court, can you please put this case back on the calendar? Either I wasn't there for a good reason, medical reason generally, and I have a defense. And if they sign the order, the tenant must have it served on the landlord. This is important because this does trip people up a lot. Again, you as the tenant cannot serve your landlord, but you could have a friend go, as long as they're over 18 and they're not, also a roommate, one of your roommates. And normally the court is going to set this up in a shorter time frame than the 10 to 17 days that I had mentioned earlier. And that's because normally there seemed to be some urgent need for this. And then moving on, so those are kind of the basics of the anatomy of an eviction. I did want to talk briefly about, oh no, I think I'm turning it over to Nick now, actually. Yes.
So this, we wanted to sort of highlight some of the more recent and significant changes in state law. And I'm not a practitioner, so David and Shruti will have a lot more information on how this works on the ground level. But just briefly an overview of some of those changes. Part M has probably the largest impact on tenant and eviction changes across the state outside of New York City and also New York City. Here are some highlights. Part M of the HSTPA bill that was passed and adopted in 2019 prohibited what was called the tenant blacklist, which allowed organizations to comb through court records to find individuals who have been involved in any kind of eviction proceeding and put them on what is dubbed the tenant blacklist, but it would impact the ability of a tenant to get new housing. A landlord would be able to see their name on the blacklist and just decide not to rent to them because they assume that they're problematic because they've been in housing court at some point. The bill also prohibits excessive application fees. It increased and expanded protections against retaliatory evictions. It requires a written notice before increasing the rent or before refusing to renew a lease. And that timeline is longer for longer term tenants. It requires a landlord to take reasonable steps to re-rent a unit if the tenant leaves before the end of their lease. So if you have to break your lease and you've got 6 more months on your lease, the law now requires that the landlord try to re-rent it before they try to sue you for the rest of the rent under that lease agreement. It prohibits certain application fees except for the actual cost of background checks and credit checks, and it limits late fees depending on how much your rent is. It limits security deposits to 1 month's rent and also requires that those deposits be returned within 14 days of when you move out, except unless the landlord can tell you why they need more time. And then as David kind of reviewed previously, it extended out the timeline for the written demand for rent, the amount of time tenants have to respond to a petition for eviction, and the amount of time a tenant has before the execution of an eviction warrant. So those are just some highlights. The bill's pretty beefy. It's got a lot of really interesting stuff, but these, in my experience, are some of the things that had really direct impact on the ground. And I know we have some folks who are a little bit further out from downtown Albany, so I wanted to highlight some of the changes to the protections for tenants in mobile and manufactured home parks. There are new rent-to-own protections. There's a homeowner rights rider to leases. The bill required stipends to be paid to homeowners who were being evicted because their park was being converted to a new use, and an extended period of time for notice to those changes of use. It also established basically a kind of a good cause component where the rent increases over 3% could be challenged in court, and the park owner would have to defend why they're raising the rent over 3% in court, and it had to be for things other than general maintenance. So there has to be a real structural reason or infrastructure reason that those rents were going up. And then the bill also added a number of those previously mentioned eviction protections. So this really modernized tenant protections for mobile home parks for tenants as well. I don't see any questions, so I'm just going to move on to some of the special provisions that have been enacted across the state since the pandemic. So as I mentioned, the HSTPA bill was passed in 2019. In that bill, courts do have the ability to give tenants up to a year to move under extreme hardship circumstances. That was passed in 2019. That's not COVID specific, but it is a provision that hypothetically could be used in certain circumstances. Say a person who has a physical disability and would have a difficult time finding new housing arrangements that have the appropriate kind of accommodations. During the pandemic, the state enacted the Tenant Safe Harbor Act. This effectively prohibits eviction based on the rent that was accrued during the pandemic forever if the tenant suffered a financial hardship during the pandemic. So let's just pretend right now that there isn't $2.4 billion to pay rent arrears, and I had a financial hardship during COVID, and my rent, I owe 3 months of rent. Once the moratorium are lifted, I can never be evicted for that specific rent. Now, it does have to be adjudicated. There has to be a court decision that says, yes, this was a hardship and you are eligible for this protection, but I do think that that's a really important piece of the overall framework here. And then there's also the moratoria. So at the federal level, the CDC has implemented a moratoria that protects certain tenants until the end of June. It's pretty limited in the scope because it only applies to people with certain, sorry, I'll actually pull up I think it goes on to the next one. There it is. So this is an overview of the Tenant Safe Harbor Act, just to revisit it, that you would have to have that affirmative defense. And on the CDC moratorium, apologies, you could use this hardship declaration and you'd basically be declaring that you've made your best efforts to get public assistance, that you earn no more than $99,000, or you were not required to file taxes last year, or you received a stimulus check, that you have a financial hardship due to COVID, and that you've made your best efforts to make payments, and that an eviction would likely render you homeless or make you move into a congregate or shared living setting. This is, in our opinion, for the state, very limiting. And so the state level moratoria is much broader. In December, the Emergency Eviction and Foreclosure Prevention Act stayed all of the residential eviction proceedings for 60 days. That provision is now expired, but then it allowed a tenant who's suffering any kind of financial hardship or health-related hardship to simply hand over a hardship declaration to their landlord, to the sheriff who has a warrant, to their court, to anyone who would take it, and they declare under penalty that they have this hardship, and that they basically deserve to be protected from eviction. And there were two kinds of hardships. There's the hardship, but also if you had an illness or some kind of medical condition that would make it dangerous for you to move, you could also file that hardship. This provision expires on May 1st. There is a bill that's been introduced that will extend these provisions to August 31st. There's an expectation that bill should pass on Monday. It's and I'm sure you've seen that in the news. That has not yet passed, but I think we expect these provisions to be extended. The only exceptions really are people who don't have a hardship, or people who are a nuisance in their building to the building and to other tenants, or again, people who just haven't submitted the hardship declaration. The declaration's available online, though. It's widely accessible. You can print it. It's in a number of languages. And if you have any questions, you should reach out to legal aid and they can help. And back to David. Actually, I think there was a question, maybe. No.
No questions? Okay.
Yep.
So I wanted to talk a little bit about illegal lockouts, unlawful lockouts. This is getting to be a hot topic. You know, we do see this, unfortunately. I did see it before COVID, but see it being prevalent during COVID as well. So basically, in the Housing Stability and Tenant Protection Act that Nick has talked about that was passed in 2019, there was a section that was passed in the new law that's basically defines a person. Basically, you're a lawful occupant if you've been in the apartment for 30 days or more, or if you've entered into a lease. Those are the definitions of lawful occupant. What this new law does is it prohibits landlords from taking certain actions to try to evict or attempt to evict a lawful occupant without a court order. So you always need some kind of court order when you're being evicted. That's really kind of a takeaway here. So landlord cannot use force or threaten the use of force. The landlord cannot use conduct that interferes with or is intended to interfere with the lawful occupant's use and occupancy of the apartment. And there's some examples in the law too, but it's not an exhaustive list. So no taking the doors off the apartment, no moving in the tenant's possessions, or changing locks, or shutting off essential services like utilities, electric, those kind of things, which I think I have seen all of those examples in my time at Legal Aid at least once. So it is something that does happen. What you do, moving on to the next slide. It's also unlawful if that landlord fails to take reasonable and necessary steps to return a lawful occupant to possession. Here, again, the courts interpret things a little differently. So what is reasonable and necessary might change depending on which court you're in, unfortunately. What this law does, though, it does make any of these actions a Class A misdemeanor. And it also allows a court to assess civil penalties. Each violation is supposed to be a separate penalty. And again, includes the failure to take reasonable and necessary steps. And that's one of the things that I've been, really kind of leaning on, in some of these cases is that, a landlord can make an excuse like, oh, this happened because of this, but what are you doing about it? It's not just that something happened, but it's also that the landlord has to do something about it when the tenant says something about that. And yeah, it's been changing. I said the other day, when the Housing Stability and Tenant Protection Act passed in 2019, it was a sea change in the law. It seemed like it was a once in a lifetime change. It was for practitioners, it was amazing that this came down the pike. But then COVID came and things have been changing so rapidly. It's been really interesting. But this part was added in 2019, like I said, but it's still wending its way through the courts, right? So the courts have different interpretations. A lot of the courts I'm seeing have a pretty high burden to assess any penalties. I have a case where someone was evicted on September 1st and put back in possession in April. And basically all those efforts were seen as reasonable and necessary. So there were no civil penalties assessed at this point, just to kind of give you an idea of how high that burden can be sometimes for certain courts. In these COVID-19 cases that we're seeing a lot of these cases, legal lockouts come up in the context of COVID-19. What the landlords are starting to claim is that, hey, so-and-so moved out, they abandoned the apartment. And generally they're saying that because someone left, but legally it has to be something more than just leaving, right? You have to leave and do something else that shows that you don't want to stay there anymore. So that's kind of the brief on illegal lockouts. I want to move on to nuisance evictions, which I'm going to talk about objectionable tenant, and there's also an eviction for illegal activity. We'll focus more on the objectionable tenant thing because that.
I apologize for interrupting. I'm sorry. We do have a question for you. So before you move on, I thought I'd go on and read you this question real quick. The question says, when it comes to the eviction process and items left behind of a month-to-month lease, you mentioned the landlord must tend to the tenant's property for a period of time. Does this include a vehicle? And there is more to the question, but it does seem a little situationally specific. If you want to look over that and determine whether or not it's appropriate to answer. But generally, would it include a vehicle, I think is the question.
Yeah, I mean, we're here more for legal information. And just as a hypothetical though, I don't know. I think that it generally, it would really depend. It would really depend. If your lease, for example, said something about parking spaces, then potentially. But where are you parking as well? Where's the access? So I think that's going to end up being a fact-specific thing that you might be able to make an argument in court. Generally, though, what we are dealing with is belongings inside the apartment. Because the other thing to keep in mind is if the vehicle is moved from outside, it could be the landlord, it could be someone else, right? I think when you're looking at an apartment that is locked up, the assumption is that if things are missing from there, the only other person with the key is the landlord. So it's seems pretty obvious that that's what happened to what's in the apartment. So I'll just kind of leave it there. I don't know. I give you the lawyer answer. It depends. Just moving on to objectionable tenants. An objectionable tenant is someone who has violated a term of a lease. There must be an actual clause in the lease that says you can be evicted for being an objectionable tenant. And the landlord has to prove these allegations by competent evidence. And this also means not just that the landlord has to prove something happened, but also that it was against the lease, right? It was a violation of the lease. You can't just say so-and-so did something that I didn't like. It has to be something that violated the contract and the agreement between the landlord and the tenant. Illegal activity. I won't go into this too much except to say that there's basically a method for people who is basically like when there's I think this is referred to as the body house law, where there is, something going on. Normally it's prostitution or drugs or something like that, that the neighborhood wants to kind of clean up. There's a different process for that in the law. And I just wanted to mention that real briefly, but mostly we're thinking about objectionable tenants here because it plays into the COVID Emergency Eviction Foreclosure Prevention Act. I always have to count them out on my hand. One thing to keep in mind with an objectionable tenant, though, is normally there's what's called an opportunity to cure. If you have a written lease, a lot of times it'll say, if you've violated this, then the landlord, should let you know and give you a certain amount of time to kind of take care of whatever the issue was. It also has to be something that can be taken care of. I think one of the issues that it has come up a lot lately, and there's a lot of cases on this, is animals, because there can be support animals now. But I have seen cases where, whether it was a support animal or not, someone had an animal that was supposed to be a violation of the lease, but then the animal is gone before they brought the proceeding. So, that has already been cured. That's what cure means. You've already taken care of whatever the issue is. And there's also, as of 2019, in some of these cases, there would be a potential stay for 30 days at the end of the eviction proceeding, if it is a condition that the court sees that the tenant might be able to cure. And so that used to be just down in the city, but now it's all over the place. So moving on to CFPA. So there are exceptions. Nick mentioned this hardship exception or hardship declaration that will potentially stay in eviction till May 1st or August 31st now, potentially. There is an exception. Well, first of all, obviously, if you don't file one, you're not qualified to those stays. But if you do file one, there's still an exception for someone who has persistently and unreasonably behaved in a way that substantially infringes on the use and enjoyment of others or causes a substantial safety hazard. If this is an eviction that had already been started when this law was passed, the landlord has to amend the petition officially, and they have to serve it on you also. And the other thing is, this is not just mere allegations. This is a high burden on the landlord to prove this. I've heard some different standards from different courts about what the actual burden is. I have seen, I think a lot of the pending evictions, some of the landlords are trying to say that that they're persistently and unreasonably behaving in a way, even if it wasn't the case to begin with. There are some courts that have said, for example, what's persistent and if it's persistent, it has to be somewhere near where near in time to where the law was passed. For example, something that happened in July of 2019, or even October of 2020, that has since ceased. It's not happening anymore. That's probably not going to be persistent. This is going to be an area of the law, I think, that I know I have a couple cases, so we're going to see a little bit more of how this plays out. I definitely have had some cases where sometimes the petition wasn't even amended. They just kind of go into court and try to orally say, well, this person's doing this. And, well, for example, I do have a hearing next week to see if the stay applies through tomorrow, basically. Saturday. Well, now August 31st, but so this is a very interesting piece. Generally, it's going to be a higher burden to prove persistent and unreasonable, and also substantially infringing on someone else, or substantial safety issue. Very high burden. I've had cases where I've been able to use defenses, some of the ones that we'll talk about later, just to kind of start to chip away at what the landlord is saying. For example, having someone who lived in the apartment. There's something called the roommate law in New York that a lot of people aren't aware of. And I think, in days past, decades ago, it used to be used to discriminate against people, or it was to prevent discrimination, because prior to same-sex marriage and recognition of relationships, landlords might try to evict someone who lived with a tenant who wasn't quote unquote family or part of the household. So there's this roommate law that allows for another occupant to be there. And now that I've gone off on that tangent, I'll think I'm passing this over to Shruti. Oh no, back to Nick.
Yeah, apologies. We were asked to cover discrimination in fair housing, so I wanted to just go over some of that body of law. It's illegal to discriminate based on a person's race, family status, color, national origin, religion, disability, or sex. State law in New York adds that it's illegal to discriminate based on creed, age, sexual orientation, military status, or marital status. And then many local governments have adopted additional protections. And discrimination, in housing really gets to sometimes really overt discrimination, but in other times systemic discrimination or implicit biases. This can be things like refusing to sell, finance, insure, or even just to show somebody housing, or refusing to make housing available if it was available to somebody else, setting different terms, circulating discriminatory advertisement. And that one you see a lot on Craigslist for apartments. It'll say, I only want this kind of person, blah, blah, blah. Refusing or to make or provide information about a loan. And then, the really obvious stuff: harassing, threatening, intimidating, coercing, including sexual harassment. There's also in New York and in a lot of municipalities first, but now statewide, protections against source of income discrimination. It is illegal to deny someone housing based on the type of income you're receiving. So you cannot be told that you are not going to be rented to because you would be paying your rent with a Section 8 voucher. There is an exception here for 1 and 2 family owner-occupied homes, which is the case for most discrimination, sadly, and then also dorms and boarding houses and certain senior housing. There are additional protections against discrimination as a person who has been a victim of domestic violence. You cannot be rejected for subsidized housing because of domestic violence. You can't lose your apartment. As a tenant, you have a right to bifurcate or separate out your lease and either remove yourself without being penalized by your landlord, or have an abuser removed from the lease without penalizing you. A housing provider cannot require you to provide documentation of abuse. So this comes up frequently where persons who are victims of domestic violence get priority in housing or in housing assistance. So if you go back to the rent assistance program that we just passed, that's getting kind of up and going soon, one of the priorities there available is for people who are victims of domestic violence. And then you say, well, how does the agency know I'm a victim? And the fact is they can't force you to prove it. You would just self-certify that you are a victim of domestic violence. And that would just be built into the application that you are submitting, under penalty of law. So the state law also prohibits housing discrimination based on your status of domestic violence. Except when you're living in a building when the owner also lives and that only has, 1 or 2 units. So again, there is a carve out for owner occupied buildings between 1 and 3 units, depending on the specific of the law. That discrimination is still sadly allowed under the state law. But we do, the state does allow you to break your lease if you have an order of protection. So you can get out of leases. This is a little bit mixed up here in the slide. I should have reorganized it, but there are protections to let people out of their lease and not be penalized, which I think has been a change over the years. And then, years ago, the state passed the Sexual Orientation Non-Discrimination Act, but it wasn't until 2019 when GENDA was passed, and the 2 laws together prohibit discrimination based on sexual orientation or perceived sexual orientation, but also on gender identity or expression, including transgender status. And those carry over into housing protections as well. And then there are also some protections at the city and county levels that go even beyond what the state does on what these kind of discrimination protections look like. There are additionally protections for people with disabilities. Under the fair housing laws, the landlord cannot refuse to make reasonable accommodations or modifications. Buildings that were newer buildings built after 1991 have to meet certain accessibility requirements. I wanted to throw that in there just to try to capture the broadest sort of groups of discrimination that are really commonly seen across the state, especially in housing. And now I get to turn it over to Shruti, and thanks for being patient with all of this. I'm gonna go mute.
Thank you for everyone else for being patient for this section. We're gonna change gears a little bit. As my introduction said, I'm a foreclosure prevention attorney at Legal Aid, helping homeowners that are behind on their mortgage. We also once in a while, get cases of tenants that are in foreclosed homes or homes that are going through foreclosure. So if anyone has questions, I'm not focusing on that really today, but if anyone has questions, you feel free to ask. So what do you do if you have fallen behind on your mortgage payments? The first thing we tell our clients and tell people that we do trainings with, that you need to contact your servicer. Every loan is different. Depending on what kind of mortgage you have, the relief that you may be eligible for might be different. So the first thing you would need to do is contact your servicer. During the COVID duration, there's been a lot of relief for homeowners that are behind on their mortgage. None of that relief is automatic. So again, you would have to reach out to your servicer to find out what you might qualify for. There are solutions available ranging from forbearance to loan modifications to repayment plans. Again, your servicer will identify these these options for you and tell you what you would qualify for. There are free HUD certified housing counseling agencies all over, Capital Region in different counties So if you were to, you need help applying with a loan modification or forbearance option, you can seek help in one of those HUD certified counseling agencies. The one important thing that we also tell clients is please be aware of scams. There are a lot of scam agencies in New York State, in our counties, that we come across on almost a monthly basis. I see some new agency pop up. And not all of them are local. Some of them are in Florida, some of them are in California that are reaching out to homeowners here. They know that this population is distressed, going through some kind of issues, financials, financial concerns, and that's the vulnerability they want to target. And we see more often that a lot of people that are behind on their mortgage payments will actually use up their savings to pay attorneys in Florida and California and hope for that help. Please know that there is free counseling agency and legal services agencies that are available in your state, in your area. So reach out if you do receive the problem is these scammers, I guess, find an easier way to reach out to homeowners. They'll have flyers, pink flyers that they will tape on the door. Records are online. They're public records once a case is filed, so they know that there's a delinquency, someone has fallen behind, and they will target that population. So reach out for help. There's Attorney General's office has their website. You can identify. You can put in the information of the agency that has reached out. Find out if that's a scam or that's legitimate. Google them. Find a way to make sure that the person you're reaching out to is legitimate, is an attorney, and is going to do the help that they promise for the money that you're paying them. The foreclosure moratorium that is in place right now, there is some sort of moratorium may or may not be available, depending again on the kind of loan you have. For any federally backed mortgages, and those are any loans that are insured or governed by Federal Housing Administration, which is the FHA, Department of Veteran Affairs, which is VA, USDA, which is the rural loans, or Fannie Mae and Freddie Mac. So if your loans are insured or owned by any of these 5 agencies, then you have a federally backed mortgage. And the moratorium on those foreclosures or those mortgages is until June 30th, 2021. The moratorium is both on new filings and on pending cases. So if you already have a foreclosure case pending, but you have one of these federally backed mortgages, you are supposed to be in a moratorium right now until the end of June. For any non-federally backed mortgages, which is basically everything outside, other than those 5 mortgages, you are governed under your state law. And in New York, we have what panelists here have been talking about, the CEFA, the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. And under that, you can go to the next slide. Under that, we have, as my colleagues talked about, if you have lost income or had increased costs during this pandemic, the COVID-19 pandemic, and you sign and deliver a hardship declaration form, in a mortgage case, you would do this to your bank, your servicer, or if you're going through a court proceeding already, you can also send it to the court. And if you do that, your foreclosure case is stayed until May 1st, 2021, now potentially be extended to August 31st, 2021. If you may get this notice from your mortgage company, they should let you know what physical mailing address or email address you should be returning this form to. You can send it to them, or like I said, if you're already in a foreclosure case, then you can also return this form to the court. I will say that some courts are doing some conferences. Every foreclosure case in New York goes through conferences. So you might, if you're in an active foreclosure case right now, you might be getting scheduled for conference, even though you think that you qualify under one of these stay provisions. You should find out if you've know that you've submitted the hardship declaration. If you have, you're eligible for the stay. There might be some settlement conferences to still initiate and continue with loss mitigation, which is allowed. In fact, recommended that you should continue loss mitigation efforts with your lender, but just know that no action can be made on the foreclosure case before the end of that moratorium, whichever one applies in your situation. keep a copy of the hardship declaration that you've submitted, for your records. Know that any forbearance or moratorium, is not saying it's a cancellation of your mortgage payment. The payments are still owed. I've had clients that, have made some payments, even though they were in a forbearance, but then were out of the forbearance at some point, weren't really sure. I'm telling them all to keep track of their payments that they make, keep proof. You will need that once you're out of the forbearance or at the end of this moratorium to figure out what the next step is. What is it that you owe in order, for you to catch up and to find out what the next option will be for you in order to, fully cure the default and come out of the forbearance. This is a chart of the foreclosure process in the state of New York. So it goes from right at the start of missing a mortgage payment to the end where if the whole process completes, then a foreclosure auction is scheduled. Thank you. So I'm not going to go through the whole process with you in detail, but I will just highlight the ones that we feel are important and also the ones where we want people to contact us for help. So as the foreclosure case will start once you've started to fall behind on your mortgage payments. If you've missed a couple of payments, it says you have to be 120 days behind for the lender to start sending you notices of default and start to tell you that you're behind and that you need to catch up. One of the first notices that you'll get from your servicer, which is the company that sends you the mortgage statements. Those will that servicer, that company will generally be the one that would send you these pre-foreclosure notices as well. So the first notice that you would get would be a 90-day pre-foreclosure notice. It would specify that you are X number of days behind on your loan, that you need this amount of money to catch up, and it will give you 90 days to make that payment and cure the default. And if you didn't pay what you were, how much you were behind, then they could potentially start a foreclosure action against you. The next step would be if you didn't pay your default in your pay or arrears, then a foreclosure case is filed with a foreclosure summons and complaint. This is filed in the Supreme Court of where the property is located. And then depending on how you are served with this foreclosure, summons and complaint, it would depend on how much time you would have to respond to this foreclosure summons. We can go to the next slide, talking about the answer. So the next step for you in the foreclosure process would be to answer the foreclosure summons and complaint. This answer is a legal document and you have a right to answer. You have, like I said, specific time to answer depending on how you are served. If you are served personally, which means someone hands the summons and complaint. I'm doing both landlord, tenant, and foreclosure. So I go back and forth from petition to complaint. But if you're served with a foreclosure summons and complaint, personally, that means someone handed it to you, then you have 20 days to answer from the date you were personally served. If you were served by any other means, by someone leaving it substituted service, someone left it at the door and then mailed a copy to you, then you have 30 days to answer, and it's from the time they file the affidavit of service. That is proof of how they served you. There's been some change in law over the past years, and we have additional time to answer, which is 30 days from your first conference. So every foreclosure case in the state of New York has to go through a mandatory settlement conference. I will rephrase that. Every residential foreclosure case has to go through foreclosure settlement conference. It's mandatory, and that's also to give people additional time of 30 days from that first conference to answer. The idea is that hopefully you are referred to one of the legal services agencies in your area at that first conference by the court, and you have assistance in order to submit that answer in case you haven't already done so. The answer will allow you to raise defenses to the foreclosure action. Any defenses, like in other cases, if not raised timely, are waived, and that's why it's important that you submit this, legal document. Again, one thing we keep telling people that there are, like I said before, there are also scam agencies and people out there that are offering to help people with this answer. We know of a few culprits that are, you know, offering $400, $500 to do this answer. They would just check off every box on the answer. It's a form answer that we would also use for a client that we were representing. But they would just, you know, go through the whole form, not necessarily be an attorney advising you on any of these legal issues, which is, you know, it could be highly detrimental to your case. And that's why we say, you know, be aware of such agencies and reach out to legal aid as help is available for this, for representation during the settlement conference part, you know, and any other legal issues. With that, I will hand it back to any questions.
I did want to circle back around if I could just, there was one very, very important thing that I forgot to mention, and just as a practical piece of advice, I mentioned that a cell phone with a camera can be your best friend. Take pictures of all documents that you're filing with the court, keep them on your phone. If you don't have the space on your phone, maybe if you do have email on your phone, maybe you could email them to yourself to keep them, you know, in the cloud. Take pictures of your lease so that you have those on you as well, especially if there's something brewing with your landlord or you suspect something might happen. That way you have a copy of your rental agreement too, if anything comes up. So it's always nice to document things, and that's one of the lessons I've learned over the past 14 months is nowadays it's just as good to have it on your phone. You won't be able to bring your phone into court, but you'll be able to reproduce that to bring something into court.
I know there are new requirements that tenants can ask for proof of payment too from landlords, and landlords do have to provide that. But also that things like text messages between you and your landlord can be really useful in establishing, you know, efforts to reach out or letting them know that there's a problem with your apartment and things of that nature. So saving all of those communications can be really helpful. We just wanted to provide some resources too. Obviously, Legal Aid of Northeastern New York, which is represented here, is a tremendous resource. There are other organizations in the area that do some of this as well. The Legal Project, Empire Justice Center are also legal resources. Lawhelpny.org can help you find legal assistance or even pro se, you know, documents, for example, or answers to really basic questions. It's a really helpful tool for finding attorneys or practitioners in different areas across the state. So I do recommend checking out that website. It's very broad. It covers a tremendous number of legal issues. So please do check that out. And then if you do experience discrimination, you can file a complaint at the dhr.ny.gov. If you experience a fair housing violation, you can file a complaint at the AG's website. And then for help, there is emergency housing assistance on the OTDA website. And again, that portal isn't quite open yet, but I think we're hoping that it'll be up and running within the next couple of weeks. So do check back there frequently. And you can also apply for utility assistance on the same website, OTDA. That program's called HEAP. So that will be able to pay, you know, some of your utility arrears if you've experienced arrears this year as well. So that program will be expanded under the OTDA regulations to help spend some of the funding that was received by the state from the federal government. So that if you had applied last year and you weren't eligible, or you already got help but you need help again, I do encourage you to check that website back out again.
And we do have a question for the panelists. I'll go on and read it out to you guys. The question is, what about when a tenant-landlord case closes? The landlord is supposed to keep the deposit in a bank, creating interest. How does that work in an eviction process?
I can jump in here. From a practical point of view, the courts, they're separate issues. They're separate proceedings. Generally speaking, the security deposit is something you would go to small claims court over, and generally not wrapped into the actual eviction proceeding, because the only money that's supposed to be attached to this eviction proceeding is rent. And that was one of the changes in 2019 too. It used to be that you could call something additional rent in your lease and charge for it. No longer the case now. Yeah, so.
Yeah, I would just add that the interest on your deposit is frequently so tiny that the landlords can usually just claim that it's they use the interest for administrative costs, and I don't actually know anyone who's ever gotten interest back on their deposits. So I don't know that you want to spend a lot of time pursuing those couple of bucks, but you know, obviously you can ask.
And that's exactly what I see too. I don't know that anyone's ever gotten that interest.
Yeah.
For what it's worth. I mean, that I think the other thing with that, the new law though, is I think you mentioned, but the landlord does have to tell you why they're keeping any of your money, I mean, of your security deposit within the 14 days after you vacate, I believe. So.
Yeah, it cannot be kept for normal wear and tear, and any expenses have to be itemized.
Awesome. Well, thank you to our panelists so much. Real quick, we had a question. Do we have any questions from anyone? I'll leave it open for, you know, I don't see any, but just in case there's any last minute questions anyone might want to ask. No hands raised or anything like that. So, all right, we have this scheduled till 2:30, but we'll go on and wait. Never mind. Oh, no, thank you. It's a thank you message. My apologies. All right. Well, thank you to everyone who attended today. And thank you especially to David, Shruti, and Nick. You guys were amazing. I think it was incredibly informative and super helpful. So thank you to everyone. And we are going to go on and close up.
All right. Thanks, everyone.
Thank you.
Bye.